All right, good afternoon and welcome everyone. Thanks so much for joining us today. We're excited to welcome you to the 12th webinar in our ongoing series on the convergence of wetland science and technology. Today marks the 1-year anniversary of this series, and as of this meeting, we've officially crossed over 6,000 attendees to the webinar series, with dozens of different industry leaders having contributed to the different discussion topics that we've covered. Today, our group of panelists and presenters will be discussing the pitfalls of ping-pong Wotus policy and the impact that it's had on both the regulatory and consulting space, as well as environment and infrastructure. We'll introduce the full panel shortly, but first, a huge thank you to everyone on the panel for lending your time and expertise today. For everyone who's joining the webinar, please use the Q&A button down at the bottom of the Zoom window and feel free to ask any questions as you think of them. We're going to save the live Q&A for the end, so please make a note of which panelist your question is for so we can make sure to direct them accordingly. Also note that today we're going to be recording the webinar, and everyone who has registered will get a follow-up email linking you to the video as soon as it's ready. Our host today is Jeremy Schewe, Ecobot's Chief Scientific Officer, who brings with him nearly 2 decades of experience as a professional wetland scientist and environmental consultant. And with that, I will go ahead and hand the reins over to Jeremy.
Great, thanks, Alana. And yes, as she mentioned, very excited for this amazing group of presenters and panelists that have come together today to talk about where things are sitting in relationship to waters of the United States in respect to policy, in respect to regulation of waters of the United States, as well as to the consulting side of things as well, and what we're all seeing happening across the board right now. We had a great time coming up with the title for this one. I don't know, for those of you who have ever played or watched ping pong, it kind of feels like that's where things have gone with policy around waters of the United States with the last few administration changes. And so I know that there's a lot of frustration in the industry, both from the consulting and regulatory side of things, but also from the development and infrastructure side of things. So we're hoping that today will illuminate what we are looking at here in our current point in time as we're moving into the peak of field season for a lot of the consultants and regulators. So of course, needed to pull up a great image of an old ping pong table here just to kind of reiterate the back and forth nature of how things have rolled with time. We're going to see a great presentation by Donna as well as by Matt Stahman, which will help enumerate that and give us an idea of how the actual waters have shifted with time. But I wanted to bring this slide up just as a reminder, just the importance of what we are doing in this industry as stewards of natural resources, the important role that plays for our nation and for generations yet to come. So once again, thank you for joining us today, and I hope you'll enjoy your time with us. And do feel free to add your questions to the Q&A channel down below. Just a quick synopsis of what we're going to be looking at today. We're going to do some brief introductions to our presenter team here shortly. I'm going to do a very, very brief intro to Ecobot for those of you who are visiting us for the first time and aren't aware of what role that we're playing within the profession here. And then we're going to get into the heart of our presentations. Donna is going to be talking about sort of the upswing, the past, the root of Wotus. Matt Stahman is going to be talking about waters of the United States in respect to the Navigable Waters Protection Rule. And then Gordon Shaw is going to be giving us a great update in terms of what he is seeing with working on 404 and 401 projects across the nation, and what that looks like for an enterprise company. And then we're going to cap it off with Roy Gardner, giving us a little bit of an update in terms of litigations around the Navigable Waters Protection Rule. We'll have a brief slot for what our next webinar in June will be focused on, and then we'll have hopefully a good 15 to 20 minutes for conversation or and questions that you all may have or think of throughout our time together. So without further ado, here are the presenters and panelists who have joined us here today. We have Donna Downing. She's the Senior Legal Policy Advisor with the Association of State Wetland Managers. She was also previously a jurisdictional lead with EPA, working with 404 and 401 processes. And so very excited for Donna to be joining us today. Matt Stahman with Resource Environmental Solutions. He's the Director of Regulatory. And Matt is working with a lot of mitigation and restoration projects across the country. So also brings a really excellent national level view to things. And then, as I already started leaning into a little bit, Gordon Shaw, as the Senior Wetland Specialist for Burns and McDonnell, does a lot of the reviews of all of the permit applications across the country. So he's working with a lot of different regulators. And so it's just really seeing the variability of the review process and how the Navigable Water Rule has impacted those reviews and submittals. And then again, Roy, who's a professor at Stetson University College of Law, is going to be updating us on the litigations and where things sit legally. So I think we've got a great group of folks here, and I'm going to do my best to just let them run with what they have to share with us all. I think they've got this is a great perspective. So very high level briefing on Ecobot, and what we're doing over here on our side out of Asheville, North Carolina, is we have built a software package that allows delineators to collect all of their Army Corps of Engineers data and all of their shape files in the field and send that remotely via the cloud, and be able to do remote edits as well on projects, and saving a lot of people a lot of time and energy. Pretty excited about what we've been able to come up with and continue to build as a peer-driven company and software package from within the industry. Because the heart of it is we are growing this from not only within the industry, from my own experience, but also from all of our customers who weigh in. We've got a great customer advisory board that helps us to direct where we're moving things in the future into other service areas. And so very excited about what we've been able to do, and a lot of the white papers and case studies that we've been able to pull in from the last 3 field seasons. I'm very excited moving into our 4th field season. And yeah, so I'm just leave it at that. If you have more interest, reach out, or you can, of course, you can find out more information on the Ecobot website. So let's bring it back around to why we are moving in this direction. Again, waters of the United States, something that the definition of these terms have been in sort of this nebulous place for my entire career and before I started with this work. So I'm very excited that we've got a great group of people who've been entrenched in the ditches and in the water with me as we dive into the waters of the United States. So I'm going to go ahead and introduce welcome our first speaker, Donna Downing with the Association of State Wetland Managers.
Thank you, Jeremy.
Donna, you're welcome.
All right. I appreciate the opportunity to join you all today. I've been asked to discuss how the definition of waters of the U.S., or Wotus, has evolved over the decades, because with Wotus and many other issues, the past is indeed prologue. This is kind of hard to do in a few minutes, so by necessity, it will be a 50,000-foot overview. Next slide, please. Great, thanks. Clean Water Act regulates discharges to the navigable waters, a term rather vaguely defined in the statute as waters of the United States, including the territorial seas. Now, these ambiguities inherent in the Clean Water Act's statutory provisions and legislative history help explain some of the confusing aspects of Wotus. Also, there's one single definition of Wotus for all Clean Water Act programs, and whether a particular water body is jurisdictional as a Wotus, a water of the US, is a key threshold question for deciding if the water is subject to the regulatory provisions of the Act. If it's not a Wotus, it's not. If it is, it is. It's pretty, as I say, threshold question. So with the inherent statutory ambiguities and a great deal at stake, it's not surprising the scope of Wotus has been the focus of extensive rulemaking efforts over the decades, and as well as subject to considerable litigation, including 3 US Supreme Court decisions so far. With respect to Clean Water Act jurisdiction, the past is prologue. Many of the Clean Water Act jurisdictional issues raised today by the regulatory definition of Wotus and challenging the courts were present in earlier definitions. Next slide. Thanks. The regulatory definition of Wotus has been reviewed by federal courts many times, beginning with the 1975 case NRDC v. Callaway decision of the District of Columbia District Court, which held that Congress intended the Clean Water Act jurisdiction to be as broad as the Commerce Clause allows. And EPA and the Army Corps also explicitly referenced the Commerce Clause in their definitions of Wotus starting in the 1970s, including both navigation-based commerce and interstate commerce generally. Some of the details of the 2 resulting definitions are shown on the slide here. Next slide. By 1979, the agencies, EPA and the Corps, had the same definition of Wotus, which looked very similar to that in place until 2015. This definition is often called the 1986 definition, even though it was in place earlier. Reinstating the 1986 definition was an initial step, first step taken by the Trump administration as it worked to repeal the Obama administration's 2015 Wotus definition. As a general rule, courts after the NRDC v. Callaway case and before the US Supreme Court decision in Swank fairly consistently applied the principle that Wotus should be interpreted broadly, as broad as the Commerce Clause allows. Next slide. So with a broad-based definition of Wotus in place, Congress and executive branch policymakers began to grow concerned that maybe jurisdiction might include some waters beyond those intended to be covered. And in response, guidance and rulemaking efforts of the agency shifted in focus, defining what was excluded from waters of the United States while continuing to emphasize the importance of interstate commerce. Initial efforts to narrow the definition of Wotus resulted in a 1979 EPA regulation that was excluded from Wotus waste treatment systems, including treatment ponds and lagoons, designed to meet the requirements of the Act. In other words, they had to be treating something. In 1993, EPA and the Army Corps promulgated a second exclusion from regulatory definition of Wotus for prior converted cropland, or PCC. PCC includes wetlands manipulated to grow commodity crops sold in commerce prior to 1985. And in Federal Register preamble language in 1986 and 1988, EPA and the Corps provided examples of waters generally not considered to be waters of the United States, including features such as non-tidal drainage and irrigation ditches, excavated in dry land, and artificially irrigated areas that would revert to upland if irrigation ceased. And this preamble language affirmed emerging agencies' practice of the time. In the scope, the applicability and permanence of exclusions remain a hot issue today. Next slide, please. Another longstanding issue with Wotus is the extent to which geographically isolated wetlands and waters can be waters of the United States. In 1985, in response to a congressional inquiry, then EPA counsel Frank Blake indicated that isolated waters can be Wotus if they're used by migratory birds or endangered species. And this language was included in the Federal Register preambles from 1986 and 88 by the Corps and EPA, illustrating the kinds of commerce links the agencies felt were sufficient to assert jurisdiction over a water as a water of the United States. The examples included use of the water by habitat, as habitat by migratory birds or endangered species, or to irrigate crops sold in commerce. And these examples became known as the Migratory Bird Rule, even though not a rule, it's preamble language, nor entirely about birds. Then the US Supreme Court ruled in Swank in 2001. Supremes held that isolated intrastate non-navigable water cannot be considered Wotus based solely on the presence of migratory birds, effectively invalidating the so-called Migratory Bird Rule. Swank did not invalidate the regulatory definition of Wotus, but qualified how it was applied to isolated waters. Next slide. Supremes addressed the question of Wotus again in 2006 in the Rapanos decision. And Rapanos explored the extent to which non-navigable tributaries and their adjacent wetlands were Wotus. The 4-1-4 split decision didn't help clarify the situation. There was not a majority opinion, in other words, although all justices seemed to acknowledge that Wotus was broader than just traditional navigable waters. Two standards emerged, the plurality's relatively permanent standard and Justice Kennedy's significant nexus standard. The court, again, did not invalidate the regulatory definition of Wotus, but qualified how it was applied. After Rapanos, EPA and the Army Corps issued guidance indicating that a water should be considered a Wotus if it met either Scalia's relatively permanent standard or Kennedy's significant nexus standard. And this is articulated most recently in this December 2008 Rapanos guidance. Scalia and Kennedy standards use jurisdictional terms that differ from those typically used by aquatic scientists. You have relative permanence, continuous surface connection, similarly situated, significant nexus, isolated. And so the implementation challenge for agencies as well as the regulatory community was, does a particular water have the characteristics called for by the legal terms as defined by the agencies and the courts? Rapanos resulted in a surge of scientific research and papers on connectivity among waters, exploring in a scientific context the new legal concepts of significant nexus and relative permanence. Next slide, please. Now, after Rapanos, a water's relationship to traditional navigable waters largely determined whether that water was a waters of the United States. Jurisdictional either because it flowed to the traditional navigable water, at least seasonally, thus meeting the relatively permanent standard, or because it had a significant nexus to the traditional navigable water, satisfying the significant nexus standard. The next presenters are going to give an overview of Obama administration's Clean Water Rule from 2015 and the Trump administration's Navigable Waters Protection Rule from 2020. So I'll just note a couple of things. One is the two regulatory definitions take a very different approach about the degree to which science informs the scope of waters of the United States. Clean Water Rule acknowledged in its preamble that science alone could not determine jurisdiction since the definition had to be within the authority granted by the Clean Water Act and consistent with the overall statutory framework and construct of the Act. Nevertheless, the Clean Water Rule relied heavily on aquatic resource science to inform its definition of waters of the United States. The Navigable Waters Protection Rule replaced the 2015 with one more consistent with Justice Scalia's relatively permanent standard from Rapanos. Rule's preamble emphasized the definition is based on law and policy objectives, including acknowledging states' primary responsibility and authority to manage its water resources, and downplayed the role of science. Indeed, the EPA's Science Advisory Board, an independent body, noted that the Navigable Waters Protection Rule, quote, offers no comparable body of peer-reviewed evidence and no scientific justification for disregarding the connectivity of waters accepted by current hydrological science. Next slide. Thanks. Changing definition of Wotus is a challenge, as we all know, to federal agencies, states, tribes, and the regulated community who are trying to operate in a manner consistent with the Act and its coverage of waters. And as EPA and the Army Corps consider revisions to the definition of Wotus, debates over what the definition should be are likely to continue raising the role of commerce, exclusions from the definition of waters of the United States, status of geographically isolated waters, and the role of science in informing the scope of Wotus, among other issues. It sort of has a step back. Maybe we're at the 60,000 foot level at this point. Why is Wotus such a complex and recurring issue? There are a lot of reasons, some of which are on this slide. It's a threshold question, determining whether the Clean Water Act regulatory provisions apply or not. Its scope is tied to Congress's Commerce Clause authority to enact the Clean Water Act. And so it evolves as the courts consider the scope of the Commerce Clause itself. Wotus is posed and defined in legal terms, the interpretation of which are informed by science, but there's an imperfect fit between the law and the science in the terms of the terms. Some view Wotus as a vehicle for raising other large issues, such as property rights or federal state responsibilities for environmental protection. And Wotus has many institutional players with strong opinions. So with that, I'll close, turn it back to Jeremy, and look forward to hearing from my other co-presenters. Thank you very much.
Great, thank you, Donna. Great ramp up for us here. So our next presenter here is Dr. Seuss. And the first time I heard Dr. Seuss speak was down at the Wetlands Conference in Houston. Oh, I'm sorry, it's Matt Stahman with Rez. So Matt, you want to go ahead and kick us off?
Yeah, Jeremy, I'm just going to take us on a very quick, brief tour of what have been waters in the United States and what are waters in the United States today under Navigable Waters Protection Rule. And most of these slides are just being provided mainly for reference purposes for folks. I'm not going to spend a whole lot of time on them, but if you want to go ahead and start the progression of what has been waters in the United States, I'll kind of talk us through them. So as most of y'all are probably very familiar, we've seen a lot of different features on the landscape be considered waters of the United States, all the way from the territorial seas, traditional navigable waters, and then up the watershed through perennial streams, intermittent streams, ephemeral streams, and all those adjacent wetlands and impoundments that surround all of those features on the landscape, including some that are separated behind artificial or natural structures. And there's been this is the sort of the ping pong table, if you will, for the entire presentation, because every one of these features at some point in time has been looked at as a water of the United States or has been considered a potential water of the United States. If you want to click to the next slide, real quick, Jeremy, there you go, including all those classes of wetlands. If you want to click to the next one, which I think puts us at post-Rapanos 2008. So this was the landscape of jurisdiction post-Rapanos 2008. And you can see there was a lot of just straightforward jurisdictional waters, but also the gray features on the landscape were waters that were being considered on a case-by-case basis. And this was a fairly complex landscape to navigate. For those of us who have dealt with wetland delineations or jurisdictional determinations under the U.S. Army Corps of Engineers, every project came with its challenges to figure out what was a water of the United States. If you want to click to the next one. And then came the Clean Water Rule during the Obama administration. EPA 2015 put out the Clean Water Rule. It was finalized in 2015, if memory serves correctly, and it attempted to lend some certainty to exactly what were waters in the United States and take some of the case-by-case considerations out of the post-Rapanos landscape. The biggest difference here that I saw with the Clean Water Rule were the addition of the distances. And you can see a few of those represented on this graphic, the 4,000 foot distance being the longest of the distances under which waters were considered either jurisdictional if they were within a certain distance from other jurisdictional waters, or potentially jurisdictional on a case-by-case basis, as is that 4,000 foot reach. That distance provision only showed up in the final rule, not in the draft rule, and I think that's what basically generated a lot of the concern and the pushback, if you will, from different interest groups around the country on that rule. Long story short, it was replaced, if you would click to the next one, with the rule that we have now. And you can see how jurisdiction has been, quote unquote, simplified under the Naval Waters Protection Rule Trump EPA proposed in 2020 and was finalized June of this year, if I'm not mistaken, date-wise. A lot of areas that had formerly been considered jurisdictional for the first 40 plus years of the Clean Water Act were no longer considered jurisdictional under this rule. But I'll call your attention real quick to a few key phrases here, which I'll go into just for a couple of minutes. Inundated by flooding, contributes surface water flow, and direct hydrologic surface connection. These are the phrases that are somewhat leading to interpretation or open to interpretation in some cases, district by district now. Sort of lends itself to some of the gray area of interpretation that we're seeing moving forward. So let's click to the next one. This is the rule, at least paragraph A of the rule. There are only 3 paragraphs. Basically, it's very simple. If a water is not listed in these 4 subparts of paragraph A, it is not a water in the United States. And if you don't believe me, read paragraph B where it says exactly that. Paragraph C goes into definitions. But jurisdictional waters under Naval Waters Protection Rule, as that last slide showed, are very straightforward and simple. Territorial seas, tributaries, impoundments in certain cases of jurisdictional waters, and adjacent wetlands. Next slide. These are the key phrases that apply to those terms, however. The inundated by floodwater, contributes surface water flow, and direct hydrologic connection, many of which we've heard over the years used by the Corps of Engineers, but probably the most important as far as wetlands are concerned is that inundated by floodwater from an adjacent jurisdictional tributary or other water of the United States. And all of these are caveated with being in a typical year. Next slide. In a typical year is defined as a rolling 30-year period of averages of normal periodic range. So that's brought into play a new consideration as to what is normal or what is a typical year, as it could basically change year to year as we see weather patterns shift and change across the country. Next slide. I want to highlight some of the definitions that have been clarified or tweaked, I should say, in the Naval Waters Protection Rule, paragraph C. Adjacent wetlands, the term intermittent as it applies to streams, the definition of impoundments of jurisdictional waters, and next slide. The definition of tributary, and then a typical year, which I showed you earlier. I just want to point out some of these highlights. If you're working with the Naval Waters Protection Rule, these are some of the most critical definitions that I've seen. Next slide. This is the new definition of adjacent wetlands or adjacency. Adjacent wetlands. Adjacent wetlands do include all wetlands that abut. That's nothing new. Jurisdictional waters, and they also include wetlands that are inundated by flooding. Key phrase again. In a typical year, by the territorial seas, a tributary, a jurisdictional tributary, or an impoundment of that tributary. The draft rule, I want to point out, had the phrase direct hydrologic surface connection to inserted there as far as adjacent wetlands were concerned. That was struck in the final rule and replaced with inundated by flooding in a typical year. Hydrologic surface connection does still apply to wetlands that are physically separated by an artificial barrier. And if there is still a direct hydrologic connection, those wetlands are still jurisdictional. Next slide. Tributary was redefined or clarified, I should say, to define as any river, stream, or similarly natural occurring surface water that contributes surface water flow in a typical year. And by contributing surface water flow, very specifically, tributaries, as far as jurisdiction is concerned, are limited to perennial or intermittent channels. They do not include ephemeral channels any longer. Next slide. It is important to note that tributaries do not lose their jurisdictional status in certain circumstances, which you can see here, including a channel that might go through subterranean portions or has been channelized for some portion of its length. Next slide. Intermittent was somewhat clarified to mean continuously flowing during certain times of a typical year and more than in direct response to precipitation. Many of us who dealt with the definition of intermittent streams previously used by the Army Corps of Engineers were used to the phrase not in direct, intermittent had to have some sort of influence by groundwater at some time of year in order to provide some of its flow. That is not in the definition anymore, although it is pointed to as an example. It does sort of open questions as to what is more than in direct response to precipitation. Could that include artificial sources? It definitely could include snow water melt and some of those other things, as long as you have more than flow that's only being driven by direct precipitation. Next slide. And then caveats were added to lakes, ponds, and impoundments of jurisdictional waters, specifying that they do also have to have contribute surface water flow in a typical year to those other jurisdictional waters, or they could be inundated by flooding in a typical year and still potentially be considered jurisdictional. Next slide. And then there were caveats on when they don't lose their jurisdiction, very similar to streams. We'll go on to the next slide, Jeremy, and I think I'm wrapping up. Very good. And that is the end of my presentation. Looking forward to questions.
Thank you, Matt. And so, yeah, if you have questions, feel free to direct them in the Q&A channel down below. Excited to introduce Gordon Schewe next, who's going to be talking a little bit about how the ping pong policy, how that's affected the consulting side of things. So Gordon, if you want to go ahead and turn your mic on and come on in.
Yeah, thanks, Jeremy. Yeah, my name is Gordon Schewe. I'm a professional wetland scientist. I work with Burns and McDonnell Engineering. I am based in Kansas City, Missouri. And today I'm going to talk about some of the changes we've seen in working with the 404 process with our clients. A lot of the work that I do is wetland delineations, and then we also do wetland permitting as well. Next, just so you know, I wanted to give you a photo there of what I look like with regular field clothes on, rather than my suit and tie that you saw on the advertisement for this. Of all the attorneys and the CEOs on the advertisement there, I was the one who looked like the attorney. Next slide. The Navigable Waters Protection Rule, as Matt already explained a little bit, took effect last year. It became effective June 22nd of 2020. And like he said, it includes specific waters that are listed as jurisdictional, including territorial seas and traditional navigable waters, tributaries, lakes, ponds, impoundments of jurisdictional waters, and adjacent wetlands. And then another key thing it points out are certain features that are not considered jurisdictional. Next slide, please. And the first one is the catch-all that Matt mentioned earlier. It includes, so everything is excluded unless it was included in the first four. Some of the important ones here that also lists as well are ephemeral features, and lists all these. I'm going to just highlight a couple of these. Ephemeral features, prior converted cropland, water-filled depressions, which may occur after construction events or mining operations. It does also specifically include a definition of waste treatment systems, which you see is the last one listed there. If you want to go to the next slide. I wanted to give you some context for the information I'm going to provide in my presentation. And So we at Burns and McDonnell, we deal with a lot of our clients are electrical transmission companies, also pipelines. We deal with linear transportation, also some industrial and some commercial clients. In the areas that we work and the information I'm going to be providing today, we have a lot of clients who are in the Midwest here, going from Kansas and Missouri over to Illinois and Ohio. We have some down in Texas. We also work in the East, Tennessee, Virginia, and Pennsylvania. A lot of the clients and a lot of projects that we work on receive authorization by nationwide permits. We don't work a lot with individual permits, and so that's affecting what we're seeing in the current situation as well. Next slide, please. Some of the things that we're seeing, I just want to highlight here at the beginning what I'm going to talk about. We're seeing that less waters are considered jurisdictional. We're seeing the need for less or fewer pre-construction notifications, and I've got a question mark there, and so I'm going to explain that as well. We're seeing some state responses to the new rule and also some permitting changes on a federal level as well. Next slide. The first thing we noticed when the Navigable Waters Protection Rule came out was that the waters in the upper reaches of the watershed are being excluded. They're not considered jurisdictional anymore, especially ephemeral streams, and then wetlands adjacent to those ephemeral streams. These are waters where a lot of times the farmers are not farming these areas, probably because they're too wet, and maybe a channel there as well. And then some of the waters right adjacent to those. We're also noticing a more distinctive change in farmed wetlands. It seemed like before the rule, there was more of a gray area. Sometimes farmed wetlands would be considered jurisdictional and sometimes not. We've seen it where it seems like that's more of a black and white issue now, whereas farmed wetlands will not be included. And it could be because there is no significant nexus test that would include them as waters of the U.S. It could also include that some of these farmed wetlands, even if they were considered jurisdictional, they would be maybe adjacent to an ephemeral stream and therefore not included. Next slide, please. We're noticing that there may be a need for fewer PCNs filed, and that's because there's less impact caused by streams, less ephemeral streams, less wetland impacts. That 300 linear foot limit may be a moot point now with the new pre-construction or with the new nationwide permits that have just come out. We're also seeing less question, at least by the clients, less ambiguity, less concern on what is considered jurisdictional. Including the definition of a waste treatment system, which is specifically called out in the new rule. I think it's just giving the clients a little more certainty or a little more understanding, a little more confidence that they understand the rule and the regulations correctly when they see those things specifically called out, that they are making the decision that they understand the rule and they have decided based on the rule and they're comfortable with not having to file a pre-construction notification or based on what they're reading. Next slide. We're noticing some state responses to the rule, including the one in Colorado, where the states are concerned that less waters are going to receive protection. And so a stay was issued in the Colorado courts, and the Navigable Waters Protection Rule was not effective there for some time. It has now become effective there. We're seeing some states assume responsibility of the 404 program, including in Florida most recently. Other states are assuming jurisdiction of those areas that are now excluded from federal protection, including in Ohio, which has now an ephemeral stream permit, whereas you may not need a federal permit to fill an ephemeral stream in Ohio, but you will need one from the state of Ohio. Next slide. There is an argument that there may be less time needed for permitting, and that's due mainly to less impacts, fewer individual permits. However, if you are going to try to argue to the Corps of Engineers that a stream is not ephemeral, you may need to seek an approved jurisdictional determination. We're noticing that streams are assumed guilty until proven innocent. They're assumed jurisdictional unless you can prove to the Corps that it is intermittent. You may be able to do that with historical aerial photos, also using the antecedent precipitation tool. And then you may need to make the Decision there, is it best to assume jurisdiction and move on? Can we get a permit for these anyway? And next slide. There may have been a brief time of slow response from the Corps when the new rule came out. I didn't really notice it. If there was, I mean, it was probably because there were many projects in a queue waiting for it to take effect so they could apply for permits. Any change is now, any slow response is now back to normal, with the exception of that there are many other changes happening now too, and they may be affecting your response as well. Yeah, next slide. Let's see, next slide, please, Jeremy. Yeah. So with the fewer permit applications, we've noticed that there's less costs, less mitigation. That makes for happy clients, happy applicants. That's the result we've seen on the permit applicants. So next slide. Delineators, at some point, it may be easier to determine what's a water of the U.S. and what's not. There is no significant nexus test now. You do need, however, to identify that direct connection to waters of the U.S., as Matt pointed out. And you may need to also to prove that a stream is not a jurisdictional stream and prove that it is ephemeral. Next slide. So in summary, we found that fewer waters are considered waters of the U.S. There may be fewer PCNs, probably because the impacts are less. We're seeing some responses from the states and then also some changes in permit processing and the data needs. Jeremy, I think that's all the slides for me.
Great, thanks, Gordon. Certainly appreciate that. So last but not least, we have Tom Petty. I'm sorry, we've got Roy Gardner with Stetson University. So thanks for joining us here today, Roy.
Thanks, Jeremy. Thanks to you and everybody at Ecobot for the opportunity to participate here, and great presentations by Donna, Matt, and Gordon. Full disclosure before I begin, I'm part of a team that has filed amici briefs on behalf of scientific societies in the current Wotus litigation. And of course, you're wondering why Tom Petty? Well, in light of the Navigable Waters Protection Rule, the regulated community is probably saying, hey, there's no jurisdiction, so don't come around here no more. Environmental groups, on the other hand, their responses may be summed up as, don't do me like that, or we won't back down. And, thus there has been much litigation filed, as is traditional with anything involving Wotus. And in the litigation context, the waiting is the hardest part. And that's where we are right now. We're waiting on the Biden administration. Next slide, please. Next slide, please. Did it not go?
Maybe you might have a delay. We're on your third slide now. Do you want your second slide?
Second slide, sorry, second slide. So at least 12 cases have been filed challenging the Navigable Waters Protection Rule, including by the Washington Cattlemen's Association and the New Mexico Cattle Growers Association. And they are contending that the Navigable Waters Protection Rule is too broad, that the scope of the Clean Water Act should actually be narrower. Next slide, please. So most, however, are challenging the Navigable Waters Protection Rule as being too narrow, that is, not protecting enough waters. And cases have been filed from sea to shining sea, from New York to California and places in between. Why is that? Well, because when the regulated community challenged the Obama administration's Clean Water Rule, that case actually went, or one of those cases actually went all the way to the US Supreme Court. Not on the merits, but on the question of which court had jurisdiction to consider Clean Water Act jurisdiction. So it was very, very meta. And the Supreme Court in National Association of Manufacturers versus Department of Defense held that challenges to the definition of Wotus must begin in U.S. district courts, not in a court of appeals where you might be able to consolidate it nationally. So it starts in the U.S. district courts, and that's what the regulated community wanted. They wanted the opportunity to forum shop, perhaps, pick and choose where they might file, say the Eastern District of Texas. So now that's great when you're challenging the Clean Water Rule, but of course now environmental groups and others who are challenging the Navigable Waters Protection Rule can also avail themselves of that rule and can file in any U.S. district court in the country. Now, so far, there's only been preliminary skirmishes regarding whether a preliminary injunction should enjoin the Navigable Waters Protection Rule. And as Gordon has noted, as of today, no. The Navigable Waters Protection Rule is in place everywhere. In California, for example, in that particular case that was brought by about 20 states or so, the U.S. District Court denied the request for a preliminary injunction, but still has not decided the case on the merits. Next slide, please. As Gordon noted, initially there was an injunction granted in Colorado, but the 10th Circuit has reversed that. So therefore, the Navigable Waters Protection Rule is in effect everywhere. So what is happening in the litigation? This is where we're waiting. So right now, nothing is happening, and that is because courts have stayed the proceedings to give the Biden administration a chance to consider its legal position. And thus we wait, although some stays have recently been lifted, such as in South Carolina and shortly in California. Next slide, please. So what are we looking at in the future here? So what are the legal grounds for these cases once the stays are lifted? So from a legal perspective, you can divide the challenges into process challenges and substance challenges. On the process, you're going to you will see claims made that the rule is arbitrary and capricious for failing to consider comments, or arbitrary and capricious for failing to explain the rationale for the change, or failure to consider the impacts of reduced jurisdiction. With respect to the substantive challenges, it would be that the Navigable Waters Protection Rule is an unreasonable interpretation of the Clean Water Act. Well, what if the Biden administration says, okay, we have decided not to defend the rule? Does that mean these cases go away? No, not at all, because you have industry groups that have intervened. So they are now intervener defendants, and they will defend the rule. They will pick up the mantle to defend the Navigable Waters Protection Rule if the Biden administration cedes that ground, which I kind of expect it to do. So what will happen, though, if the Biden administration says, hey, court, Your Honor, we should continue to delay trying to resolve this in a judicial forum because we are going to embark in a rulemaking? I don't think a court is likely to stay the proceedings because, as we know, a rulemaking can take a very long time. And also, we don't know what the result of the rulemaking will be. So I think we will see some of these cases proceed, even if the Biden administration decides to go forward with a rulemaking. Now, let's say that a new Biden rule is issued, or maybe they will go with the two-step approach that the Trump administration did with repealing the Navigable Waters Protection Rule first, which would then bring us back to the 2019 rule, which is technically the pre-2015 status quo. If they do this, then that should actually moot out this current round of litigation. And then, of course, we would then start a new round of litigation. But what happens if a court actually strikes down the Navigable Waters Protection Rule in the interim before the Biden administration does anything. What happens if the court says, yes, the Trump administration was arbitrary and capricious in some way? Well, it will very much depend on the scope of relief in terms of how broadly the injunction will apply. Will it apply only to the parties that are before the court? Will it be limited to the state in which the court resides? Perhaps it might be as broad as the circuit in which the court resides, or it could be a nationwide injunction. This is a complicated, controversial area in terms of the scope of these injunctions. So that is something to watch for as well. So we might actually see, at least in the interim, a ping pong patchwork policy. Now, I always like to end with a photo of my happy law students in a swamp, in a cypress swamp. And I note that I have been dealing with these Wotus issues for more than 30 years, for those of you who remember the 1989 Wetland Delineation Manual. And it's my hope that maybe during the legal career of my students that these issues will be resolved, but I promise you they will not be resolved during my legal career, and that's a hard promise. Thank you very much.
Thank you, Roy. And I apologize about the slide faux pas there. We're getting so many questions coming in. I lost control. So just a plug for our webinar in June. We're looking at June 9th. We're going to be looking at the mobile mapping landscape in respect to wetlands. So please come back out for that one. So anyway, we've got some great questions here. So wanted to start off with a question that came into, oh my gosh, this thing's blowing up. Okay, so some of the things that are coming through here from Marla Stelk. She had a question initially for Gordon, asking if there really are fewer impacts, or are there fewer impacts that are considered within federal jurisdiction that must be mitigated for due to less expansive definition of Wotus under the NWPR? So Gordon, you want to go ahead and tackle that one?
Sure. Yeah, I think you're hitting it right on. There's not necessarily less impacts to waters. The ephemeral waters would be impacted, but they would simply not be considered federally jurisdictional waters. And so when I say less impacts, I mean less impacts according to the Corps of Engineers.
Yeah, I don't know, Matt, is there anything that you might add to that from your side?
As far as less impacts, Jeremy, just one thing I would note from the mitigation side is obviously there's been a significant decrease in the amount of mitigation necessary for some of these projects. In fact, one project I would just use as an example, there was a large reservoir project proposed here in Texas, and it has its core permit, had about 50 miles of stream mitigation as part of that permit, as mitigation plan, stream enhancement, stream restoration, and so forth in that watershed. There was a revised jurisdictional determination done after June of 2020, and that 50 miles shrunk down to 2 miles. So obviously a very large impact on mitigation for those types of features that are, no longer considered jurisdictional. Great,
thanks, Matt. Well, I'd be interested from your side of things, Donna. Like, have you is there anything that you might add to that from what you guys are seeing from the state wetland managing side of things?
Well, as you know, if something isn't a water of the United States, states and tribes can still choose to protect them as waters of the state or waters of the tribe. And both states and tribes are interested in protecting their wetland and other water resources. One of the challenges is that Some states have what are called no more stringent than provisions that they've imposed on themselves, which means they can be no more environmentally protective than the federal government and the definition of Wotus. And that's a challenge because, as has been pointed out, the definition keeps changing. And we currently have a definition in place that the current administration says they're reviewing and may very well revise. What should states and tribes do in terms of increasing, for example, state and tribal law, the definition of waters of the state and tribe, and so forth? But I know that I haven't talked to a state or tribal rep that isn't interested in trying to fill the gap and isn't interested in having the federal government have a pretty broad focus. Well, there are some who would prefer a more narrow definition of waters of the U.S., particularly in states. But for the most part, very interested in continuing the level of protection somehow.
Great. So I want to pivot over to Royal. There's a question coming in from Andrew Boswell. If there is a nationwide stay or decision made by a district court nullifying the 2020 rule, do you see there being options to opt in or opt out, as many states did for the 2015 rule?
That's good. That's a good question. I don't believe the states had the option to opt in or opt out. We had a patchwork with respect to the 2015 rule based on the scope of the injunctions. So, for example, a court in North Dakota issued an injunction staying the 2015 rule that applied to 13 states. And then you had other courts issuing stays that apply to different states as well. If we have a situation where a district court enjoins the implementation of the Navigable Waters Protection Rule and does so nationwide, then that does not apply anymore. What then kicks in, we then would go back to the rule that was in place previously, which technically was the 2019 rule, which reincorporated the status quo before the Clean Water Rule. So you might refer to it as the pre-2015 status quo. I'm sure that's clear.
Great, thanks, Ryan. So I just wanted to give everybody the heads up. We are just before 1:30 here. I do want to pose a couple more questions. So if anybody does need to go, thank you for joining us today. And so the next question, I think I'm going to go ahead, and this is also coming in from the Q&A thread, and I want to direct this to Matt Stahman first, and then to Gordon. And so this is coming from Duncan Simpson, asking, from a standard delineation practice perspective, are you still delineating everything in the field only to then remove it from the final jurisdictional map later, or are you just not flagging something like a farmed wetland because it's clearly not jurisdictional?
That's a really good question. I was in the consulting world for a long time. Now I'm not, I'm on the mitigation side. But if I were still in the consulting world, my conservative nature would push me to go ahead and map everything, and then deal with throwing it out later on, just so I had the data. But I don't know that I would necessarily send everything to the Corps in my delineation report. I might take that through and comb through that as to what legitimately fits the criteria for a Naval Waters Protection Rule right now before I send it in. I would also add to that, Jeremy, it depends on the district. You got to know your regulators, and some districts, they want to see that information up front and they want to make the call, and others don't. They want a very limited set of information before they make that call. So it's going to depend on your district.
Yeah, I would agree with that. I mean, I've seen such variation with the states and when we're have boots on the ground. So Gordon, really love to hear your weigh in on that too, especially since you've got eyes on a lot of the country as well.
Yeah, I think especially with the ephemeral streams and ephemeral waters, we're mapping those. We map those, and then really what the Corps of Engineers is asking us for is if we think that those are not jurisdictional, they want to see us prove it.
Yeah.
So what they're asking us for is to look at historical aerial photos and then to run the antecedent precipitation tool for the times of the year when those photos were taken, and then to justify it. So if you look at the historic aerial photo and it shows this is a dry area, or this is a dry, and it shows that it's dry, it doesn't show any channels, but the antecedent precipitation tool shows that this was a wet year. Well, if it's not showing any channels in a wet year, then it probably is ephemeral. And you can look at it the opposite way as well. If it's a wet year, and it does not show a channel, or maybe I just mixed that up. Anyway, use those both together to demonstrate it. I think for the farmed wetlands, we've had some clients who have asked us, who have told us, we've talked to the regulators in our district, and we don't think that there's any need to do farmed wetlands, to delineate farmed wetlands. And so they've asked us to not delineate those. So they're comfortable with that. But then again, I think if you look where, what's the history of this and what's going to happen in the future, it's good to have that data in case something does change, then you've got it.
Great. I don't know if Donna or if you or Roy would want to add anything to that from your side. No. Okay, great.
Oh, actually, I will.
Okay.
I think that the approach that Gordon and Matthew have been talking about of while you're in the field, gather the data makes sense. Going back to the theme of this webinar, ping pong definitions, it may become relevant in the future if it's ephemeral stream and where that stream is, or a wetland adjacent to an ephemeral stream. It would have been relevant under the 2015 Clean Water Rule under the Obama administration. So it's often better to collect the data so that your analysis can remain as nimble and flexible, perhaps, as the changing definitions of waters of the U.S.
Great. So I want to direct a question back to Matt and maybe Gordon as well. But there's two questions that came in on the Q&A channel, one from David Fowler and one from Mason Bowles. And basically, these are kind of in respect to looking at precipitation and how those might be affecting a decision. So David's question is in respect to the 30-year average. Does that include potential future hydrology or just past hydrology? And then Mason's question is in respect to the APT tool. So I know we haven't really spoken to that today. The antecedent precipitation tool, of course, is a tool that was created by the Army Corps of Engineers for helping to attain that the data that is necessary to show whether we're in a normal year or not. But I wanted to open that up for you first, Matt.
Yeah, just with respect to the first question, it's a 30-year running average of previous climate data. So I guess you'd update it year by year for your region based on your state climatologist reports or whatever you can get for that particular region that you're wanting to deal with. And I'm not as familiar with the antecedent precipitation tool. I know Gordon can speak to that, but I do want to take the opportunity to point out as far as determining whether or not a stream channel is intermittent, ephemeral, or intermittent or ephemeral being the main cutoff there for jurisdiction. Donna, you're probably familiar with this, the stream flow duration assessment methods, SDAMs, which have been used in the Pacific Northwest, if I'm not mistaken, for some time. There is an effort underway to update and expand those SDAMs across the country to have a rapid tool in order to decide whether or not, based on a field visit, whether or not a stream is intermittent or ephemeral. So I just want to put that out there for folks. It's easy to look up online.
Great. Yeah, Gordon, are you guys using the APT tool?
Yeah, we've used the precipitation tool. There's I think it hasn't been officially released to the public, but you can find the beta version of it, and we use it, and it runs the 30-year rolling total or average of the climate for the past 30 years, and then it compares it to what you found out there on the site that day. It has results on there from the Palmer Drought Severity Index, the WETS tables, And it's got that 30-year rolling period too. So it gives you a little bit more information than just running one of those other tools will by itself.
Yeah, great. Okay, so we've got a question being directed at Donna here from Cynthia Paschke. Do you know if Ohio has no more stringent than provision? If not, where would you look to find out? Ohio EPA is regulating drainage ways and ditches, not ephemeral streams, as waters of the state.
I don't believe it does, but I wouldn't count on a rather aging memory on that. There's a couple of places you can look if you're comfortable with 10-year-old data to get you looking. The Environmental Law Institute has a study on no more stringent than provisions where it looked at all 50 states and unpacked this idea of self-imposed limitations on being more environmentally protective than the feds. Even if you're not interested in 10-year-old or 12-year-old data at this point, you might go there because it would give you citations for where there wasn't one, which if they had since enacted one, it would appear there. But I believe that it does not. I know that the state of Idaho has an absolute prohibition on being more environmentally protective than the feds, and I believe there are something like 8 states that do. Some of those limitations on being more environmentally protective than the feds isn't a prohibition, but calls for the regulatory agency to do more process while they're putting in a more environmentally protective rule. For example, they have to brief the legislature or get permission from the legislature. There's various types of additional steps. In some contexts, that's almost the equivalent. Additional process is almost the equivalent of a prohibition, but it's not as complete. So I would take a look at the Environmental Law Institute report. It's quite interesting, even though at this point a little dated.
Great, thanks. Roy, anything you want to chip in on that as well?
No, I think Donna covered that well. I did see in the chat box there was a question about the ESA and does the presence of an endangered or threatened species in an ephemeral stream somehow affect Clean Water Act jurisdiction? The answer is no, it does not. Now, it might affect how under the ESA, it has implications, because if you have a jurisdictional water and a listed species, then you're dealing with Section 7 and the consultation process. If you're dealing with a non-jurisdictional water and a listed species, then you're kicked over to the Section 10 process under the Endangered Species Act, and that can be a bit more open-ended.
When I was at EPA, I got at least a handful, if not more than that, requests from project proponents who had gotten a jurisdictional determination saying that waters their project would affect were not waters of the US. They wanted us to work to try to flip that, make it jurisdictional so they could be covered under, as Roy characterizes, the somewhat easier Section 7 consultation under the Endangered Species Act. Just, the first one I got of those, I had to scratch my head for a moment, but it makes a bit of sense.
Great, thanks, Donna. So we've got a really interesting one coming in from Julie Kelso, and she's directed this to Gordon, but I think this could be fun for everyone to play with. It's in respect to frozen streams. So how do you interpret flow duration if a stream is frozen under NWPR? If a stream is frozen for weeks, month, and then only flows for a few weeks, is it considered intermittent? And I'd love to maybe toss that out to Matt first, and then we can kind of go around the horn on that one.
That's a good question, but I mean, just me thinking about frozen streams. I'm in Texas, so I don't see very many frozen streams. But if I had a stream out there up in the north that was full of water and was frozen for months on end, it probably, in my mind, would be an intermittent stream channel. I wouldn't think that would be something that only runs off and during a precipitation event. But without absence of just some rapid tool, I'd go back and I'd try to pull together I don't know, flow data or whatever I could find for that region, or just come up with some sort of an argument as to why either it is potentially an ephemeral channel or it is a potentially intermittent channel, based on whatever climate data I had at hand. If I was up in the northwest, I'd definitely look at that S dam that they use up there.
Gordon, you want to chime in?
Sure. Probably similar to Matt, I don't deal with frozen streams a lot, and so I haven't spent a lot of time on this part of the rule, but there is some specific language in there that talks about if the stream flow is a direct result of ice water melt. And I think it still qualifies as an intermittent stream, but I think you might need to look into the rule for sure. But it does specifically talk about if the stream flow is a result of ice water melt.
Great, thanks, Gordon. So I know things don't freeze very often down in Florida, Roy, but love to hear from you on this one.
Yeah, I'm in Florida. I don't deal with that. So I mean, it sounds like what Gordon and Matt were saying is sort of the right approach and the proper considerations.
Great. Donna, anything you'd want to add?
I concur with my colleagues. I also think that the NWAPR focuses on ephemeral streams that flow only in response to rainfall as non-jurisdictional, and I don't read much in the either the rule or the preamble that suggests if it freezes, either as a stream or for that matter as a wetland, that the intent was to keep it out. I think you need to look at other criteria to get there.
Great, thanks, Donna. And while you're still speaking, Donna, Judy Murray Burns had asked, you had referred to a no more stringent paper in one of your responses earlier. She was wondering what the source of that was.
The Environmental Law Institute, if you do a Google search or Bing search, I guess I shouldn't express a preference, although I do prefer Google. You go to the Environmental Law Institute website, you can find it there. It, I believe, is a free download. And again, its data at this point is maybe 10 years old, but it's quite exhaustive. And because it gives citations, they're lawyers, they always do that. It's easier to then track those citations up into 2021 and see what currently is going on.
Great. Well, thank you, Donna. And we are almost a quarter past our time here, so I think we better cap it off here. Donna, Gordon, Matt, Roy, thank you so much for joining us today. All of your expertise, I very much respect and appreciate you taking some of your time from your busy schedules to join us. Again, I apologize for a couple of the glitches that we had there, but we've done it, and we have had a nice revisit to Wotus. As things warm up, make sure you get out and swim in some Wotus near you. So, all right, well, thank you, everyone, and we'll look forward to seeing you next time.
Thanks very much.
All right, take care.
Take care.
Yeah.
Bye.